folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you? All right. Who's responsible here?
What's that?
Who's responsible here? Whose house is this?
Yeah, haven't been drinking or anything, right?
No.
Okay. Drive careful, okay?
Thank you.
This is what the other group had that ran away.
Oh, really?
You just ditched it?
Awesome.
Yeah, those ones kept walking in the car and the other one.
It's truly for the win.
That I was given to. So there was 2 different discs. Okay? They all knew about it.
We're not here to talk about the alcohol stuff, okay?
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
And ice noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Welcome to Truth and Transparency. Tonight is the kickoff of the preliminary hearing for Dr. Daniel Moore. Brian Drake murdered. This was the preliminary hearing. This took place. We're going to have Bella on. She will be. This took place on October 2nd, 2020. He was arrested 8/27/2020. Again, this was, COVID was March. The courts were using YouTube to stream some of their stuff, believe it or not. So what's up, Bella? Hi.
Hi.
What's
Hi,
up? How are you?
everybody. Good. How are you?
Just
Are
about
we on
ready to blow
Tuesday?
some minds, huh?
Oh my gosh, we're doing the prelim right now.
Mhm.
Can you hear me?
Mhm.
Hi, everybody. How are you guys doing on Tuesday?
Great. Good.
Tuesday doesn't get its own name. Like it's not hump day or like thank God it's Friday day.
What's that? What's that in the background?
I don't know. Hold on.
She's playing in traffic right now. So let me go ahead and
Is that better?
better, about the same. We're at the eye doctor.
I don't know. I sound
Yeah.
really loud in my own ear.
Oh,
Gosh. I can hear all my mouth noises. I hate mouth noises. Okay, here we go. Just tell me if I sound robotic. Hi, everybody. Did you guys get snacks for this?
Snacks.
I just have like strawberry punch. That's all I have.
Okay, so you guys, you're gonna be able to tell exactly how things are playing out. There's really not much to say. It's just like, let's all check it out. Let's see what goes on in this preliminary hearing. So
tell us who everyone's gonna be, Lana. Who are
Yeah.
you? And who am I?
okay, I'm gonna have Bella play the lovely defense
No, you said
and
you.
prosecution.
I mean, I'm better as a defense expert, but like, go ahead. You're going to be defense. You know, I rock it with defense. But okay, you be
No,
defense.
I'm just kidding. Bella's playing she's playing the part of the detective. So she's on the stand.
I'm the witness.
Yes. Yes.
Okay.
As well as the prosecution. So like she'll be doing her own objections. Okay.
I object.
I object to myself. The pen is royal.
Oh my gosh. Okay, so then,
but that way you guys don't get confused.
But they don't know who Miss Bolton is. Like what you have up. Who's Mr. Hall? Who's Miss
Okay,
Bolton?
so Hall is your prosecutor. Bolton is your defense attorney. So you have Hall, prosecutor. Bolton, defense attorney. And then you have obviously the court. That's your judge. And then when it's your witness, you're going to hear from Van Leuven. You're going to hear from ISP Van Leuven, and you're going to hear from Jennifer Drake takes the stand, and Marty Ryan, which is the assistant police chief of police. Okay, so but
Get some Marty up in this.
now I was literally blown away. I want you guys to see this because I have no words. And I think the best way to describe what this is just to like live it. You guys, they
Live it.
Yeah, they play this on
Just
YouTube.
live it.
Live it. Just live it.
But okay, like, can we also just acknowledge something you brought up in your last live about this, which was the times are bizarre, right? So if you guys want to pay attention to this, is where Lana already brought this up, that like, as we know, Jennifer, if you followed the case, Jennifer Drake contends that she was on the phone with her husband for 9 minutes, 15 seconds before the fatal shot. And then you will see where 9 minutes and 15 seconds comes up again, right, Lana? Wait, why are you muted? You muted yourself?
I said we'll let that all play out.
Yes. So you guys
All right.
listen to this.
Again, hello
All right.
everybody in chat. Hello to the mods. Hello to the members, subscribers.
Thank you. The
Touch your
mods are-
DNA on one of the thumbs up or thumbs down based on your level of approval. But you guys, this is, I mean, I get it. You don't want to, this may not be the juicy part of it, but to me it is, because this is what we would have seen had Brian had a prelim. Right?
Yes, prelims are interesting, you guys, and we don't get to see enough of them.
This is like you shouldn't be going to trial. You know what I mean? This is your chance to like the judge is like, no way.
That's true. Let everybody know, because maybe some people don't understand the prelim and what a prelim is for. Please explain to us.
A prelim is a little hearing, guys. A prelim is you got arrested. Okay, just because somebody arrests you does not mean like that they have probable cause to arrest you. Now that does not mean that you did it. So at a prelim, you have a preliminary hearing to. They have to put on their little mini case to show the evidence against you and why the judge should be like, okay, yeah, this should go.
Let's go to trial.
Yeah, this should go forward.
And if they don't meet that burden, they would be like, yeah, no, we're not trying this person.
And the burden is, you guys, it's just the judge makes the decision. Okay. The judge makes the decision. There's no jury. Okay. There's no jury that decides anything in a preliminary hearing. This is the judge. Okay.
And the judge knows the laws and everything. Yes. Let's get started. You guys ready? So who's going to play the court, Elo?
I will. The court. Okay, Ms. Bolden, obviously Mr. Moore is present. Are there any potential defense witnesses in the courtroom at this time? Your Honor, there are not. Just my client's family is here, and I would note that the deputy from the sheriff's office just advised me that my investigator is here. He's not a witness. I would just like him to be able to be present because he is assisting. Is there any objection from the state?
No, Your Honor.
Okay. All right then. Bailiff, If you would please escort that individual in.
Is that Mr. Schoonover?
Yeah.
Thank you.
Della, sub girl. What
What if Della's a boy?
What's the status of the YouTube live stream? And then this is just they're talking about the YouTube live stream. There's some stuff that just, they ask basically if they want to see the screens, and both attorneys say that they do not need to see it. That's just distracting. Okay.
Okay, Your Honor, I would like to. Okay, we're not doing that.
Okay, yeah, I'm just trying to say because they just go to try to get this all. Okay, we got our live stream going.
Moving on.
All right. So the criminal complaint on file here is this alleges that defendant Daniel Lee Moore on about the 12th day of March did willfully, unlawfully, deliberately. We know everything. That's the statute. I'm just trying to save my voice. But basically, he's reading everything off. He has
he's saying what the nature of the prelim is, which Lana just explained in a nutshell, I guess. So we can just move on.
Yeah. So basically, right here, the nature and purpose of a preliminary hearing on a felony charge in Idaho is to give the defendant an opportunity to require that the state put forth sufficient evidence to establish that at least probable cause exists to support the felony. Okay. All right. Again, right here, Ms. Bolton with that explanation, and of course, the far more detailed conversations you've had with Mr. Moore. Do you believe he understands the nature and the purpose of today's preliminary hearing? Yes, Your Honor. All right, then. Is there anything else scheduled today that we'll be taking up other than this preliminary hearing? No, Your Honor. Okay. Are there any defense motions that you would like to make before I turn the floor over to Mr. Hall to call the state's first witness? Your Honor, we would move to exclude witnesses. I think the parties have already compiled with that, but we just make sure that the official motion for the record. Additionally, I don't know how the court wants to address it, but I did file a motion 2 days ago to exclude defendant's statements from consideration of this court at this hearing. Again, this is after he announced that he wanted a lawyer 5 times and they, violated his rights. So that's what she's arguing here on this motion. She says, I don't know how the courts want to address the issue. We could proceed with our motion if you would like. We would probably just call a state's witness to authenticate the video and play those portions that we set forth in our motion so the court could see them. And the court can make a ruling so that we don't spend a lot of time going through objections in the testimony. That would be our proposal, but of course, the court makes that call. Thank you. Mr. Hall, what do you say about that?
Your Honor, I think it's appropriate that we address the motion to suppress issue pursuant to Idaho Criminal Rule 5.1, dealing with preliminary hearings. It indicates in subparagraph B, subparagraph 4, about halfway down, motions to suppress must be made in the trial court as provided in Rule 12. And this is clearly a Rule 12 motion. The trial court in this reference is the district court. If the court bounds a person over, however, there's the caveat that says, however, if at.
Okay, so basically they go ahead and they go This is just long-winded. This is just long-winded. Just because they don't win it, it's just there is no suppression. There is no suppression at this hearing.
You gotta tell me. Look at how cute he is. Marty Ryan specifically was talking with the defendant about. Yeah, gotta tell me. All right, moving along.
This is all about things that we've talked about in this case. And the court says, okay, Ms. Bolden, I think what I'm understanding that Mr. Hall said is that perhaps the most, just would be to simply hear all the evidence. Hear all the evidence, okay?
Let's just get to the nuts and bolts.
So they say we're going to hear all the evidence, okay?
Okay, here we go.
She has a standing objection, though, which, is
you're
important.
You're not narrating this. We are just reading it. Let's go.
All right.
Ready? But there was Mr. Hall. Are we just moving along? Okay, we're moving along.
Okay, so now here we go.
No.
They're talking about their exhibits for that specific issue. So they're listing off these exhibits that have to do with that. So that's what they're talking about here.
That's boring, you guys. It's so boring. Moving on.
They're just talking about, okay, what we're going to do here about these exhibits and how we're going to, blah, blah, blah.
Blah, blah.
Ms. Bolden, I think what I'm saying that Mr. Hall said is that perhaps the best, most, the evidence that we have to do with that. So that's what they're talking about. Okay, what we're going to do here about these exhibits and how we're going to, blah, blah, blah. Now, we're going back and forth about how they're going to do that. They're already saying, okay, and then at the 29-minute mark, he says without an attorney. So, those are the points that they're contesting. But basically, at the end of the day, they go ahead and they play all the clips. Okay. All right. Thank you to both counsels for those arguments. I think that out of the abundance of caution, I'm going to have to listen to all the evidence before I can fairly, rule. So he says, let's go.
Your Honor,
Not too concerned with that. Yes. Okay.
I do have one other matter, deals with procedure. Okay, moving on. This is all like procedural stuff because there's not a jury here, so they do this stuff.
They can just do this out in the open. There's no sidebars here. They're just having at it, okay?
Yeah, they just go for it. No side.
All right. All right, here we go. Okay, with that, for the record, the defense motion to exclude witnesses is granted, which we've already done. So basically, people had to leave that were not, if you're going to be a witness, you can't hear testimony. So, okay. So we've already done that, but we'll just clean that up for the record. And so, Mr. Hull, are you ready to call your first witness?
Your Honor, prior to calling witnesses, we have 2 pieces of evidence to present to the court, which are stipulated to. And the first is
just so you guys know,
what a stipulation is.
Yeah, that means that the defense and the prosecutor here, they can exchange information and say, hey, do you stipulate to these exhibits just being in? That way it expedites, the
time. It doesn't waste the time. And so they agree prior, and that's spelled wrong.
To this,
It's not supposed to be TOO. It's just TO.
Okay. So thank you, Nazi.
I'm a copy editor. It just bothers me.
Okay, so
are we just going to move on past what?
No, this is actually really important, though. This part is really important.
Your Honor, okay. 2 pieces of evidence that present to the court, which are stipulated to. The first is a copy of the autopsy report that was performed by Sally Akins, who is a medical doctor and a forensic pathologist in Spokane, Washington, as well as attached toxicology reports. We would ask that be marked as State's Exhibit number 1, Your Honor. Keep that in mind, guys.
You're making it just one exhibit?
Yes.
Okay, yeah, no objection. 1 is admitted to its admission. 1 is admitted.
And the second, Your Honor, is you guys pay attention to this. And the second, Your Honor, is the 911 call that Jennifer Drake made to the Boundary County Sheriff's Department. And we would ask that it be admitted as State's Exhibit number 2 and then published to the court.
Any objection to proposed exhibit number 2? I just like some clarification. If we could get that from the state. As we understand it, Jennifer Drake called 911, but she was in Hayden, Idaho at the time. So there were several routings of the call. And so I guess we just like a representation of what it is they're playing. We don't have an objection to a 911 call, just so we're clear, but want to make sure that we understand what it is.
It's the one that, and she's actually correct, Your Honor. She, because she was in Hayden and it went into Kootenai County and then got routed up to Boundary County. This is the Boundary County call.
So it's only the Boundary County portion?
Yep.
With that clarification, Miss Bolton, thank you. I have no objection. 2 is admitted.
Okay. And with that, Your Honor, we would go ahead and call Mike Van Leuven.
Okay, Mr. Van Leuven, we're going to swear you in. So we swear him in. All right.
And you're going to play Van Leuven because I'm the prosecutor.
Yes.
Right?
Yes.
Okay. Would you please state your name and spell your last name?
My name is Michael Van Leuven. Like
Where do you work?
Like Van Halen.
Don't
I work
know.
for the Idaho State Police.
What do you do for the Idaho State Police?
I'm an investigations sergeant for District 1.
What are your roles and responsibilities?
I manage a team of, or I supervise a team of detectives whose primarily role is the investigation of what we refer to as general crimes. The majority of those crimes involve officer-involved shootings or other homicides.
Are you a POST certified officer in the state of Idaho?
Post, yes, I am.
When did you become post certified?
That would be in about 2001.
What certificate do you hold with the Idaho State Police at this time? Or excuse me, the Idaho Peace Officer Standard of Training.
The most senior certificate that I hold is a superior certificate, I think.
Is it a supervisory certificate?
Superior, yeah, something like that. Yeah.
What other certificates are there?
There's basic, intermediate, advanced, and masters, and executive, I believe.
And do you hold all of those or just...
I do not. I hold a basic, intermediate, and advanced. I was promoted before I was on the job for 15 years, so I'm not eligible to receive the senior.
Were you involved in the investigation of the death of Brian Drake in Boundary County, Idaho?
Yes, I was.
How was it that you became involved in that?
It's common for other agencies in District 1, counties and cities who have a serious crime to ask for assistance of the State Police Investigations Division. In this case, I was notified on March 12th by my lieutenant that there had been a shooting. A homicide had occurred in Boundary County, and that the city of Bonners Ferry was requesting our assistance in processing the crime scene.
After you had received that information, did you make a trip to Boundary County?
I did. I made calls that evening, and then the next morning, myself and my team responded to Bonners Ferry, Boundary County, Idaho.
Where did you go?
We went to an office building located at 6811 Main Street, Bonners Ferry, Boundary County.
Okay.
This building. Your Honor, I'm going to object. It looks like the officer is reading from something in his testimony instead of testifying from his personal knowledge. And we'd ask him to testify from his personal knowledge. The court, Mr. Hall?
I have no objection to that. That's what the rule that's what the rules say.
Okay. Go ahead.
That's you, Bolton.
Were you able to remember that, or?
Oh,
Question?
okay. Oh, sorry. You're right. Were you able to remember that, or did you refer to a report? Don't you laugh. This is serious.
Could his notes be taken away from him so that he stops referring to them, please?
That's good. That's actually really good. That's a good one.
I'll just ask him to turn his notes over and ask permission if he needs to refresh his recollection, and then we'll deal with that in case by case basis. Okay.
Did you write a report in this case?
Yes, I did.
And in the report, did you put the address of where you went?
Yes, I did.
Do you remember that address independently, or would you have to refer to your report to refresh your recollection?
Well, I just looked at my report and refreshed my memory, my memo, my recollection. So I know that it was 6811 Main Street, Bonners Ferry, Idaho, in Boundary County.
And describe what you saw when you got there.
There was a single-story office building oriented at an angle as to where one corner was facing north. Immediately to the southwest of the building was another building, which was part of a sports apparel shop as well as a coffee drive-through. When I got there, I was advised by local law enforcement that they were on scene. That objection, hearsay.
Your Honor, it's not offered for the truth of the matter asserted, just to show what he did next.
Overruled.
Thank you. Go ahead.
I was advised by local law enforcement that a doctor named Brian Drake had been shot and killed the night before in his office. I observed that there was a sign advertising him, his name as a chiropractor on the side of the building, and that he'd been shot through a window that was in that alleyway between his office building and the coffee shop. I observed a hole through a double paned window, as well as through a metal mini blind. That was my initial observation of the scene.
What further observations during that time did you make with regard to the window itself? Size, the color of the blinds, anything with regard, or the open, closed, those types of things?
The window was approximately 2.5 feet wide and probably 3 to 4 feet tall. The bottom of the window was approximately 40 inches off the ground. The hole, and you could see the trajectory of the hole based on both windows having a hole through them, as well as the mini blind. Those were all spaced out in sequence about this far between the pane window and the mini blind. And you could see a downward, trajectory where the bullet went from outside in. And I could see that from Your Honor. I object. This is speculation. There's not foundation for this testimony about the trajectory. Mr. Hall, your response?
I can lay further foundation, Your Honor.
Objection sustained.
You had mentioned the trajectory of the bullet.
Yes.
What factors did you take into consideration to determine trajectory?
I observed the damage to the windows, as well as the damage to the metal mini blind, as well as shards of glass that were visible inside the office space.
Could you tell whether or not the bullet traveling through those items that you've referenced, what direction of travel they were? Were they from the outside in or the inside out?
Yes, it was from outside in.
Okay. And what objective factors did you look at to determine that?
We observed the shards of glass that were predominantly on the inside of the room. Most particularly was the hole in the mini blinds, the metal mini blinds, which shows a circular defect with metal that is bent inward into the room.
Were those all at the same height? Were the glass from the outside, the second pane, and the shades?
No.
Which one was higher or lower?
The outermost pane of the glass showed the highest effect. The innermost part, the metal mini blinds, showed the lowest defect.
When you say the highest effect and the lowest effect, are you referring to height or?
Yes, yep.
Okay.
The height of off the ground of the holes.
So, if I understand correctly, then the bullet would have traveled through the window first and then come out of the blinds?
Objection leading. Overruled. That's correct.
And is that the trajectory that you determined?
It is. Your Honor, I'm going to object again to foundation. There's been no testimony at this point that he's had any training or experience on determining trajectory. Mr. Hall.
I'll ask some additional questions, Your Honor.
Proceed.
How many homicide scenes have you investigated?
That's hard for me to put a number on precisely, but it's got to be close to between 50 and 100.
And of those 50 to 100, between those, how many of those have been through, you wanted to say through windows? Oh my gosh, I can't believe this shit. Okay. And of those 50 to 100, between those, how many of those have been through with firearms?
Most of them.
And have you gone to any training with regard to investigations of crime scenes regarding homicides?
Yes.
What training have you gone to and received?
Well, I received training in the academy, as well as the advanced academy regarding responding to crime scenes. Since the academy, I've attended between 1,500 and 2,000 hours of advanced training, including multiple weekend-long trainings, Hooters girls, in regard to homicide scenes, both evidence collection and homicide investigation theory. Yeah.
And how long have you been using firearms yourself, personally and professionally?
Since I was a kid, about 10 years old, I think I got my first 22. Obviously, I've been using firearms since I was employed by the state police in 2001.
This is such a horrible question. And how old are you?
44.
So about 34 years you've been using firearms.
Oh, yes, sir.
All right. Your Honor, again. So is that the trajectory that you determined based upon your training and experience?
Yes, sir. Your Honor, same objection. There's still been no testimony about trajectory training. We've heard nothing. Overruled. This is actually a matter that an average person could understand upon observation. Okay.
How high was the bullet hole on the outside pane of the window from the bottom of the window? Not from the ground, but from the bottom of the window.
I can't tell you the exact height off the top of my head. That was measured both through the use of a laser measuring instrument as well as my own rough use of a tape measure, which is documented in my, by photographs. The general answer is it was a height consistent with an adult person holding a gun and standing outside the window.
And so the question I have though is that from the bottom of the window, how high up from the bottom of the window, if you have that measurement?
Hold on, I'm just choking over here. I can't answer that off the top of my head.
Okay.
It was a few inches.
How much of the window was exposed that wasn't shot? Was this halfway through the window? You mentioned something that there was 3 to 4 feet high.
Oh, yeah. No, it was at the bottom portion of the window.
Okay. After you made those observations, did you ultimately go into the office itself?
Yes.
And when you went into the office, what did you see?
I saw who I later learned to be. But just earlier he said that he knew who he was before he walked in because it was the office of Brian Drake and the people that he took over from. I saw who I later learned to be Dr. Brian Drake lying on his back on the floor of his office with his head towards the door and his feet back towards the window with his phone lying near his head.
Did you ultimately extradite his body from that scene?
The coroner, Mick Mallet did. He assisted, we assisted Mr. Mallet in that process.
Once you were inside and you observed the position where Brian Drake's body was lying, what can you tell us about your observations from this? The scene or the blind going forward into the office. So what would have been, was there anything in between the blind and the window?
Yeah, the bottom portion of the blind was propped up by a square Kleenex container. So portions of the blind were there. There were gaps. So it was visible to see through. There was a stool immediately in front of the window. And based on the trajectory of the bullet through Dr. Drake's body, we later concluded that he had been likely sitting on the stool, leaning forward when the shot was fired.
There should be an objection here. There's not, because how are they getting, okay. Was there anything between the stool and the window?
Only the mini blind.
Okay. There was no desk or table or anything of that nature?
No.
Okay. And would you tell, based upon the physical evidence there, which way Brian Drake would have been facing when he was shot?
He would have been facing with his back to the window as the front of his body leaning forward to the room.
And you're aware that an autopsy was conducted in this case?
I am.
And that is what has been admitted as State's Exhibit 1?
That's correct.
Okay, so you had indicated that you went there the next morning. So was that these observations made on the 13th of March?
That's correct.
And were you able to determine when the event would have occurred on March 12th?
Yes.
How were you able to determine that?
I learned that Dr. Drake had been on the phone with his wife, Jennifer, when he had been shot. Your Honor, I'm going to object. This is a hearsay response. Mr. Hall?
It is a hearsay response, Your Honor. I'll withdraw. About what time was it that you I'll go ahead and withdraw that, Your Honor. Do you I'm going to ask that Jennifer Drake go outside the courtroom, Your Honor, because I'm going to have to call her just to establish the time for the court.
Just a thought. We've already got Exhibit 2 admitted. Is that not sufficient to address the issues that you're trying to get at?
I'm not sure if I can't remember whether or not it states the time, Your Honor.
I don't have Exhibit 2, although it's admitted.
Yeah, and it's
I haven't seen it.
Excuse me. That's Exhibit 1. Yeah. Exhibit 2, Your Honor, is the 911 call, and I can't remember whether or not it had the time on there. And so that's the only.
When you say the call, is it a recording or is it?
It's a recording.
A transcript?
It's a recording, Your Honor.
It's not a transcript.
That's
okay.
That's correct.
Ms. Bolton, your response to Mr. Hall's request to have Miss Drake step out so she can be called as a witness? Yeah, I have no objection to that. All right, then, if Mrs. Drake would please remain in the hallway briefly until Mr. Hall calls her as a witness.
Okay, and during the course of the investigation, did you ultimately conduct interviews with Dan Moore?
I did.
Is he in the courtroom today?
He is.
Where is he at, and what is he wearing?
Sitting right at the defendant's table in the middle, wearing a dark blue shirt, blue pants, with a light blue mask on his face.
And it's during COVID, though, you guys. I had how many interviews did you have with him?
I had 2 interviews with him.
Did other officers have interviews with him also?
Yes.
Okay. Did you have an interview with him on August 27th of 2020?
I did.
And who else was present during that interview?
Good old buddy Detective Gary Tolson of the State Police.
Was the defendant also there?
He was, yes.
Well, I mean, he's asking, he's saying, what? Did you interview him? I mean, he's a defendant. Yes, I interviewed him. This is a horrible question. Okay, sorry.
Does anybody, hold on, I just want to stop right there. Does anybody see what just had happened here? Why can't the 911 call be introduced via the time of the 911 call? Like, of the time of the 911 call, that would be, your recorded 911 call, the time of it.
What you're actually asking, Lana, is why can't it be stated the time that the 911 call was placed is when, because they're saying determined time of death is when she was on the phone with her husband, right?
No,
That's what you're saying.
But I'm also saying, no, I'm also saying way more than that. Then there's so many other ways to get that in of what time, if he wants to say that the time of death occurred, at the time, I'll get to it. Go ahead. You have this guy, and you could pull up CAD notes. You could pull up the report of the log. You can do times, and if that was a fucking indication, then I don't know. It's just go ahead.
This is the prosecution trying to get the preliminary hearing done so they could indict this guy and get a trial done. I mean, and the defense needs to stand up for their client. So, okay, was the defendant there also?
The defendant was there when I interviewed him, yes.
Was that interview recorded?
It was.
And have you had an opportunity to review the recording of that interview?
Yes, I have.
How long was your interview approximately with Dr. Moore?
My portion of the interview was approximately 15 minutes long.
At the conclusion of the 15 minutes, what did you do?
I stood up and ended my portion of the interview and stopped the recording and left the room.
Why did you leave the room?
Mr. Moore had made a statement to the effect that he was going to need or might need a lawyer. I was concerned at that point that he may have been invoking his rights under Miranda. And I wanted to leave the room to think about that and listen to exactly what he had said and examine that, to make sure that I was clear in my head as to what his meaning was.
Okay. And you had, do you remember the statement that he made in reference to that? And we're going to go to, I'm going to have you authenticate the videos of these. So we're going to hear that. But do you remember that statement that was made?
I think I do. But if I could refer to my report, I have the quote written exactly.
Would it help refresh your memory?
It would.
Would you please review your report, but do not read
Your
it out
Honor,
loud?
Your Honor, I'm going to make this objection, and maybe it'll help speed things along. I think that the actual recording of the statement is the best evidence, not the officer's attempt to recount it, which I would submit, having reviewed the video many times in his report, is not accurate. Mr. Hall, your response to the best evidence objection.
It certainly is the best evidence, Your Honor. I'm just using this as a foundation as to why he went out.
We stipulate to the admission, no foundation needed.
I'll move on then, Your Honor.
All right, then. I'm considering the question withdrawn.
Okay. Did you, you said that you left the room to kind of figure out whether or not he had actually invoked his rights to counsel?
Yes, I was asking him a question along the lines of, we know you did this. It was a matter of why you did this, because the why is important. And his response was to the effect, well, if that's what you guys think, if that's what you guys are going to do, Your Honor, again, then I guess I'm going to need a lawyer. Your Honor, I don't know why we're going down the same path. We just lodged at sustained. That last objection, it was sustained. Last response is stricken.
So after you went outside and you thought about it, did you have an opinion as to whether or not you felt, as an officer, whether or not he had invoked his right to counsel?
I'm gonna object to the relevance of the officer's opinion. That's overruled. It's only being taken to show why he took a subsequent course of action.
Go ahead, please.
Yes, I left the room and discussed what he'd said with Detective Tolson, my drinking buddy, as well as Assistant Chief of the Bonners Ferry Police Department, Marty Ryan. I played the recording back of his exact words, and in listening to what he said, we all agreed that his statement was not a conclusive invocation of Miranda.
Okay, at that point or some later point, did another officer go into the interview to interview the defendant?
Yes, Assistant Chief Marty Ryan did.
Your Honor, at this time, I can bring Marty Ryan up. Just go ahead and say that he conducted the interview, or if there's a stipulation with counsel, we can go ahead and just stipulate. I have the 6 segments that were referred to by both myself and counsel prepared for the court to hear and to be played. Do you want me
What exactly is the stipulation you're soliciting?
Well, from a foundation, a stipulation for the admission of those segments that both she and I have referred to for publication to the court. And this would be the interview starting with on August 27th of 2020. with Mike Van Leuven, Gary Tolson, and the defendant, and then them leaving the room, and then Marty Ryan coming in to go ahead and conduct the interrogation after that period of time. So this is the crux of the motion to suppress and the crux of this preliminary hearing.
Do you have those recordings already marked as one or more exhibits?
I have not marked them because I have the recordings. I've got them on the thumb drive, and we can go ahead and play those.
Okay, well, Your Honor, here's what I would suggest because we're making a record here, and I don't know that a thumb drive is really easy to mark. We've made copies of all of the video recordings. So what I called MVI36, that's what you guys called it as 37, 38, 39, 40, and 41. I've got them kind of in folders that are easily marked and could be admitted. And I've also got the clips that relate to his, assertions, what we say are his assertions to write to counsel that would, were taken from them. So we stipulate, we'll play them, and the court can always look at evidence under the rules and make a determination as to what is admissible and what is not. Or if there's an objection once they see it, but I think this may be easier than, the flash drive just is hard to mark. And I want to make sure the record's clear. Mr. Hall, how do you like to proceed in that regard?
Well,
it is the court's concern that we're making a clear record as to an exhibit number associated with a particular
I
media that's being played.
understand. And we can go ahead and put them on DVDs and then mark them as States Exhibit 3, 4, 5, 6, 7, and 8.
Well, I think that's what Miss Bolton is saying she's already done. And
well, she's
not to sound critical, but why didn't the state already do this?
because we put them on thumb drives.
And that's super important.
And thumb drives have been typically used, and then we just go ahead and submit those. Are you going to go ahead? Is counsel suggesting that we go ahead and play the DVDs, or does she want the thumb drive?
I'm suggesting these be marked and then we play these. That way the record's clear.
And I will not stipulate to the excerpts that are pulled out. Best evidence is you've got the entire record, and the excerpts should not to be used to point out their specific theory of the case, Your Honor.
All right, I understand that. So let's just talk about the entirety of the recordings. Do you wish to, well, I suppose you've got a witness if you feel that somehow they're not accurate recording that could be commented on throughout the testimony if necessary, but assuming that that's not going to be a problem, how do you wish to mark those DVDs that Miss Bolton has?
If she wants to mark them as defendant's exhibit or state's exhibit, it doesn't matter to me, Your Honor. How would you prefer?
The defense says, I think we call them defendant's exhibits A, B, C, D, and E, and F. Okay, let's go ahead and get some exhibit stickers on those. Start with the temporal sequence, the ones that came first.
Do you have a way to play those?
Yeah, we do.
Okay.
We have it right here, and we're connected to that video. So
Do you want me
them
to do that? So
Yeah.
you want them A, B, C, D?
Yeah, correct, please. Yeah.
Your Honor, the only caveat is that the state has not obviously listened to those. We're assuming that they are actual copies of what we provided in discovery. So, and the other portion is if there's a stipulation, then we don't need to call Marty Ryan to lay further foundation.
Right.
With regard to his portion of the interviews, if I understand correctly.
Right. I guess if we could just stipulate that after the first tape, which is MV136, Marty Ryan comes on tape, on second tape, which is MV137.
That's correct.
And I know what Marty Ryan looks like, so sure. I'll know exactly when that occurs.
Your Honor, and I would also like to ask that Marty Ryan be allowed to be in the court during the playing of those to make sure that he can, if he notices any discrepancies, that he could draw attention to that.
Ms. Bolden? Your Honor, I know that Detective Van Leuven was there watching from the room the whole entire time. He said so in his report anyway, but I don't see the need of having a witness in to look at his own statements that are recorded. seems kind of. Would Mr. Ryan be needed as a witness beyond what's on the recording?
No, Your Honor.
So if yes, he will be needed. He will be needed for us. Oh, for events that occurred that are not captured by the recording, Ms. Bolden? I'm sorry? You'd be potentially calling him as a witness? Yes. For events that are not captured on the recording? Yes. Okay. So if he were only here to view the recording portion, how would that prejudice his testimony for? That's fine. Your other events? If it's just for that purpose, that's fine. Okay, I have no objection. So we'll just let him in for the purpose of watching the recording for what we'll generally refer to as quality control. How's that?
That would be fine, Your Honor.
Okay.
He's down in my office because of COVID. May I call him and have him come up?
Please do.
Thank you. Your Honor, do you want me to go ahead and put on the monitor?
Perhaps, Judge, while he's doing that, if we could recover those exhibits and we'll play them from here. I think we're connected through the... Why don't you go ahead and let's go off the record for a brief 5-minute recess while we work out the logistics and get Mr. Officer off the record. Okay. They're doing stuff to get stuff on there. So we're doing like the TV stuff. My preference would be to zoom in on the TV screen. I have all kinds of notes all over my table, and I don't need, this is about, because it's on YouTube. So they just talk about that, and then
Were they talking about YouTube? I had to get jelly beans.
All right, they're just talking about YouTube. All right, here we go.
Prosecution's just eating jelly beans.
Okay, so
None for the defense.
He'll keep that in mind. The best visibility, housekeeper matters. Okay, exhibits, and this is what now we're talking about. The raw DVD exhibits are marked A through Miss Bolden. What did that top out at? A through F, Your Honor.
Your Honor, and we're still on the record, but not live streaming.
We're on the record, but not live streaming yet.
And so, just from a presentation standpoint, we would like to interrupt the publication of these DVDs to have Jennifer Drake on the stand so I can go ahead and get the time reference in her statement and then publish first the 911 recording. And
is that a matter that could be stipulated to in light of all of the documentation we have? The time she called? Sure. Yeah, Judge, we don't have any objections to stipulating to the time. I know that Mrs. Drake called her husband, was on the phone with her at approximately the time that he was shot. He described it in the call. She described it in the call. That's what he told her. So, and that's on the 911 call.
so we would ask still for the publication of the 911 call, but we can stipulate to the time. Can you explain what's happening right now, please?
Well, let
because
it play
this
out
is
here.
important.
Let
Okay,
it
play it out.
Sure. I don't know that we need to play it. I think the judge can listen to it anytime.
That's the worst statement.
How long of a call is the
It's not very long, Your Honor.
recording? Let's go ahead and do that. Have you got that marked as State's Exhibit?
We have it. We put it on a CD, Your Honor.
Excellent.
We were advised, we understood by the court, we could put things on a thumb drive. So I apologize for the confusion.
And what's the marking exhibit marking on it?
Exhibit 2, Your Honor.
3, actually. We've already got a 2, don't we? Or is that 2? That is
Was that 1?
that is 2. That is
He's the one that put it in as 2.
excellent.
Thanks. Did someone say my name?
Yes.
I'm sorry.
You want it down here?
Yeah.
Okay, I guess we need to go back on live stream as we publish Exhibit 2.
Judge, at your discretion, once I press the go live button, it takes about 15 seconds to actually launch.
Okay, so let's make sure the DVD is cooperating. We're still on the record, but we're not live streaming yet.
Your Honor, I think after speaking with Miss Bolton, the preferred method is to go ahead and just call Jennifer Drake, have her give a short testimony that she's going to give, and then publish the 911 call.
Agreed, Miss Bolton? Yes, I have no objection to that. All right, then. If Investigator Van Leuven would please step down for now, we'll take a break in his testimony, and the state can call Ms. Drake out of order. Mr. Holt, do we have somebody retrieving her, Ms. Drake?
She's here, Your Honor.
If she'd please step forward. Would you please face the clerk and raise your right hand?
You're going to be Jennifer Drake now. Oh, there you go.
All right, please have a seat. There we go. Okay. Mr. Hall. All right, Ms. Drake. The way this works is Mr. Hall will be asking you a series of questions. After raising Ms. Bolton, we'll have an opportunity to ask you questions. Okay. If you don't understand a question, it's okay to say that and get clarification. If you just don't know any answer, it's okay to say, well, that's okay. All right. Okay. Mr. Hall.
Thank you, Your Honor. Would you please state your name and spell your last name?
Yeah, Jennifer, Greg, blah, blah, blah.
Are you married?
I'm a widowed.
Were you married to? Who were you married to?
Brian Stephen Drake.
What did he do for work?
He was a chiropractor.
Did he have offices in Idaho?
Yes.
Where were those offices?
Where?
Don't be dramatic, Miss Drake. It's a very simple question.
He had one in
Where
Bonners
were they?
Ferry. He had one in Sandpoint. He had one in Hayden.
Did you have a phone conversation with him on March 12th of 2020?
I did.
Where was he when you had this phone conversation, if you know?
He was in his Bonners Ferry office.
About what time was that phone call?
Well, I called him first at 6:42. He was finishing up with a patient and asked if he could call me back. So we hung up. He called me back at approximately 7:17. We talked for about 9 minutes.
You guys wait for this. Oh, really? And what was?
It was.
How did that conversation end?
Well, it was the first day that COVID was becoming an issue. We were joking about the realization of the fact that our kids' things. Your Honor, we were starting to get canceled. Object. It's non-responsive. Sustained. Could you restate a question, Mr. Hall?
I will. What did you talk to him about?
I was talking about the children, about the fact that some of their things had been canceled.
Okay.
And how his day was.
And that was due to what?
That was due to COVID.
Okay. Was that telephone communication with him terminated at any point?
Yes.
Can you tell me what was said during that time or at the time it was terminated?
Near the end? Your Honor, I'm going to object. It calls for hearsay. Overruled. Near the end of our conversation, we were just finishing up to say goodbye, and he yelled very loudly, an agonizing yell. And he yelled, I said, what? I said, what's wrong? He yelled again. He said, I think I've been hit. I think something hit me. I said, what do you mean by that? And he was stuffed. For a second, he said, I thought someone just shot me through the window. That's when I realized my next question was, where did it hit you?
Did he respond to that?
He said, I think it hit me in the side. That was it. The phone conversation went black. I yelled for him and yelled for him. And it was that moment that I thought I either need to terminate this call and I need to call 911. And that's what I did.
When you called 911, did you, which county were you dispatched to or directed to in that 911 call?
It went straight to Coeur d'Alene or Hayden, the Kootenai County. They then transferred me to the Bonners County, who then transferred me to the Boundary County.
And did your husband return?
No, I tried calling him, but he didn't answer.
And how many kids do you? Oh, Jesus.
Your Honor, I'm going to object to the relevance we talked about.
You guys, do you see where this is going? Like, what? This is the crux of their timeline.
Authenticating the 911 call? Sustained.
I don't have any further questions, Your Honor. Done and done.
Cross-examination. I don't usually offer to give the prosecutor more time, but I didn't hear a time in the testimony. Did I miss something?
No kidding.
She said the conversation started at 6:52 or 42.
That's my
Lasted
line.
9 minutes. Okay. No.
And then she had to call back and
Okay, I'll ask.
called back at 7:17.
Okay.
So now this is you. So now I have to be Drake, I guess, and I can handle this.
This is insanity.
Do you want to tell them what's
No,
happening right
no,
now?
no.
We're just gonna go. Okay, go.
So
now this is cross. So she's the defense, and I'm
yeah,
gonna
so I'm
play
the
the
defense.
witness.
First of all, good morning, Ms. Drake.
Morning.
Good morning. And just so you know, the record is being established, and you need to speak clearly into the microphone, if you could, so we can all hear you and it can be recorded properly.
Okay. Yes.
So I just wanted to clarify a couple things. You said you were on the phone with your husband, and you called at about 6:42 p.m. Is that correct?
Yes.
Yes. Okay.
Yes, it is.
And when you called, how was it that it was 6:42 p.m.?
Because I have a record on my phone a record of my phone of exactly when it was called.
So your phone recorded the outgoing call to your husband, you said, at 6:42, and he couldn't talk to you at that point, right?
Right.
And that was because he had some patients there, right?
Yes.
Okay.
Yes.
And then he called you back, you said, at 7:17 p.m.?
Yes, ma'am.
All right. And you know that, again, because it was recorded on your cell phone, what time he called you back, right?
Yes.
Okay. And you talked to him from the time he called at 7:17 for 9 minutes. Is that your testimony?
9 minutes and 15 seconds to be exact.
Okay. And that was also recorded on your phone, the record of that call?
Yeah.
And when you spoke to him on the phone, you told us several things he said. That he said, I think I've been hit. I think something hit me. I think somebody just shot me through the window. Is that correct?
Yes.
Did he tell you who it was?
No.
Did he give you any idea who it was that shot him from that call?
He only said the words that I just repeated.
Your Honor, I think for the purposes of just the authentication of that 911 tape, which she was called for, we have no further questions today.
This is the defense.
Thank you, Mr. Hall. Any further questions?
No, Your Honor. We're done.
All right, then, Mr. Drake, you can go ahead and step down, and you're certainly free to remain.
Thank you. Thank you, Your Honor. We would move for the publication of State's Exhibit 2, which we already told you what that was. But I will note that the copy of the disc that was given to the clerk was inserted into the computer for publication, and it didn't read. We had another copy that we inserted, and it does read. Okay. I don't know if there's a defect in the disc or not, but I would ask that just for the record, for clarification, that the one that didn't read, be marked as defendant's exhibit, or excuse me, sorry, don't want to put that on you, State's Exhibit number 2, which is, it has been, and that the one that is reading, the one that works currently, that be marked as State's Exhibit number 2A.
Why would we keep in the record a disc that doesn't play?
Because it's already been marked, Your Honor.
Why don't we remark one that does play? Would there be any problem with that, Ms. Bolden? No, Your Honor. Let's remark the one that works. How's that?
And that's fine. If we could mark it afterward, I mean, we don't need to mark it now. If we could just mark it afterwards, it may be that by putting the sticker, I think it was that sticker on it, it may have been, it might have caused something in that computer to just combust. So if we can just publish that and then mark it.
We could even mark it with a Sharpie. Might be the way to do it.
Oh my God, what a great idea, Your Honor. We've never marked any exhibits with Sharpies.
Stop it.
Yes, please. You
Yes,
understand?
yes, Your Honor.
But this is really ridiculous, you guys.
Why don't we do that? We'll mark it as Exhibit 2 by Sharpie rather than by sticker.
Thank you. Do you want to do that now or after it plays, Your Honor?
Well, if we've got it in there and it's all set up, let's not mess with something that's working. We'll have the clerk mark it after it's played. How's that?
Thank you, Your Honor. And do we need to do anything from miking standpoint? Thank you.
Proceed, please. Video plays. Your Honor, objection. This is not the video. This is not the audio. Okay. We object and ask that it be stopped immediately. We're trying to. Just a second. Mr. Hall, what just happened?
We're trying to figure that out, Your Honor.
Your Honor, if it's the same file you sent us. I believe Miss Drake's call comes in about several minutes into the 6-minute clip.
So we're going to have to break out.
Okay, that. How many minutes before we get to the relevant part? We've provided that to them on 9:25.
No, I understand that.
Okay.
We're talking about Jennifer Drake's. Do you have an objection?
Let's go ahead and that irrelevant whatever that was, that came in is stricken.
I understand.
It's not relevant. Let's take 5-minute recess and hopefully cue this up to the point where it's the relevant portion of the recording. We'll go off the record. We're going to stop here.
Oh, we are?
Right here for a second. They go off the record for 5 minutes. Okay. Now we're back on the record. Mr. Hall, are we queued up to play now?
We're not. And so we're going to move on to keep things moving with the videos of August 27th, 2020 interview, Your Honor.
And right there, that's where we're going to stop. You guys, because part 2 will kick in tomorrow, but this is unbelievable. I mean, unless you guys want me to continue.
Everyone's going to be like, continue. Can you just explain in a nutshell what just happened?
What just happened here is this is the state, in my humble pie opinion, trying to not play. Did anybody have what time did you call 911? Why isn't he? What is going on? What time did you call 911? Why isn't there a recording of this? How does nobody know what time she called 911? It was on her phone records. It's not. So basically what ended up happening in that nutshell is they're trying to confuse everything. They're trying to confuse
So start at the beginning about the exhibits that the state offered. Exhibit 1 was the autopsy. Exhibit 2 was the 911 call. Very clear as day. There was 2.
Yes, but what they wanted, the state wanted everything to be on a flash drive, on a thumb drive. And the defense is like, no, everything needs to have its like own exhibit. Like if you have like these discs that are recordings, they should be all separate. Okay. So they clearly did not want to play this, and they did not want Van Leuven on the stand when this was played to be having any questions to do with it. Why?
So they removed Van Leuven. Okay.
They removed Van Leuven to put Jennifer Drake on the stand. And when this was supposed to happen, the purpose of this was because when they asked Mike Van Leuven, they asked him a question. It was one question. It said, how did you determine the time, of death, of when this occurred? And he said,
the shooting.
Yeah, but they used the word the time of death, which is really weird. And he said, well, because Jennifer Drake was on the phone with her husband when he was shot. And then that was objected to. Okay. And it was that's hearsay, and that they would have to call Jennifer Drake to authenticate this time of this, and the judge is like, wait a second, why aren't we just using what you have, which is the 911 call, to go ahead and state this time that Jennifer Drake called? Okay. Because she was on the phone with him, and then she immediately called the police after, like she said, right? Because that's been her testimony. Well, guess what Lana's been saying? Isaac Funderburg came through and totally ruined it all.
He's the neighbor, for those that don't know, that called 911.
So here, in
When he
my
heard the
personal
shots.
opinion, this is called prosecutorial misconduct. Prosecutorial misconduct is when you know that the evidence you are presenting is shit. You know that people are taking the stand, and you cannot ask somebody a question that they're going to commit perjury to if you know the answer. So you cannot ask somebody a question that you know that they're going to commit perjury to, and you knowingly can't do things like, okay, we're going to play this 911 call. Well, they go ahead and they play this call, and it's not the call. It's not the 911 call. They have no idea what
It's not Jennifer Drake's 911 call that they are saying they need to authenticate. They stipulated to what, Ella?
Well, and the other thing that didn't make sense to me is Jill has her by the nutsack right
Jill
here.
is a defense attorney, Miss Bolton.
Yep, has her by the nutsack. And it's a very simple question. When she's asking, so when you called, it recorded on your phone what time the phone call was, okay? So when you called the police, that would have been the next question. So when you called the police, what did it say on your phone? Why wasn't that question asked? It's a very simple thing here. And it's like phone records. Okay, then what do her phone records say? Okay, then what about you're telling me that 911 doesn't know? Like, go get the 911 call. Go get the first 911 call, which would be her calling CDA and being rerouted. Well, let me tell you why. Because if you go get that call, that's gonna push you back like a whole, I would say at least an hour. So also, it's just, I've never heard of somebody saying that they found out about a crime happening because, oh, I was on the phone with this person. Well, then didn't she say that she got off the phone, called 911 right away? So what did her phone record say?
Well, maybe that's happened before where they're on the phone, they hear a crime. But if the time is going to be based on this time, then
they just want that to stand alone, though. Normally, if you did what you said you did, then all of this should be able to be easily authenticated. And the judge calls that out and says, why aren't we using this way to do it? That way to do it. What's going on here? Then they're purposely fucking shit up here, the prosecution, and wait for it. What ends up happening here, and we're going to continue because basically what happens with these, because this part isn't important, what they do is they play these little exhibits because they bring up Van Leuven back. We're just going to go ahead and, Your Honor, and just for the record, so everything's clear, we're going to go, clerk just mark these. I think that, a Sharpie disc, blah, blah.
And this is a defense attorney. So she said, we will use the exhibit 2 to authenticate the time. I think that was what she wasn't stipulating to. And we still haven't. There was all this distraction. So you hear the clerk going, when I do this, it's going to take 30 seconds before it loads up. You hear like, okay, we need to take a break. There's all this other stuff.
It never plays. The 911 call never plays.
It never played. And then they're changing witnesses on the stand. There's a lot. You guys can go back and listen to it again, knowing all this in your head when we're done. Go back and listen to how that played out and read it on the screen for yourselves. And this is a prelim. If this was stated, would it have gone further than this stage? Would it have gone to trial?
What are you talking about?
Asking them if they're.
Yeah, like let's.
What do you mean? What am I talking about?
No, like wait till you see what happens. It goes past this.
No, I'm saying if it was played, if the 911 call was found or not found and was played, would it have ever gone further than a prelim hearing? Because the reason we're here is to see.
Well, no, because this is the thing, though, is they were just going to play to publish it. They were both simple. They were trying to say that there's no time frame that's given in the 911 call. And so, but they just wanted to play the 911 call. And I'm over here like, playing the 911 call doesn't matter if you're not talking about what time the 911 call came in. It was for the purpose to authenticate a time of what time the 911 call happened.
Exactly. And if they don't have that.
Right here, the prosecution knows that Jennifer Drake did not call 911, just like Van Leuven knows she did not call 911 at 7:32. Okay, that is known. They know it. This is why this happens. Okay, this is exactly why this happens. And then they purposely act like a bunch of fucking idiots. Okay, to act like shit ain't playing, to act like shit ain't fucking working, and I don't know what the fuck Jill is doing not to catch on to this shit. If I'm a fucking defendant, I'm one pissed motherfucker. Because what the hell is going on? And you see it right here in the dialect. Okay? This prosecutor, this is prosecutorial misconduct. He should not have a job, and those officers from ISP should not have a fucking job. Period. That's what's happening right here. It's happening right in front of our faces. It's all being read. And look at their acting. Oh, we can't fucking do this. And oh, it's not working here. And then they're acting stupid like, oh, we put it on here. And that's all a distraction. All of it's a distraction. And I have no idea why people are stipulating to a damn thing. How do you not know that Jennifer Drake didn't make a 911 call? Her phone records, the interviews. She says she didn't make a damn 911 call. Did you read it? Did you look at the CAD notes? Did you look at her phone records? Was it buried? This broad didn't call 911 at fucking 7:32 or 7:29 and all that fucking bullshit. It never fucking happened. And they knew about it. And this is their way of burying it. And when you want to look at the fucking Idaho 4 case, maybe this will wake people the fuck up. Because this is fucking crazy. Period. This is what just took place here. We just read it. There's no other way to look at this. And then he wants to rename a fucking exhibit. And it ain't over. It ain't over what they try to do here. This isn't over. When we continue, I was reading what they do is then he pulls the fucking number 2 exhibit and says he wants to withdraw it from being on the record. Wait for it. And I cannot fucking believe that anybody would pay $1 for this type of a defense. That's how pissed off I am to see this shit. Anybody who would have just opened up a discovery and looked at it would know what the hell was. Well, let's take a look from the beginning. What do you mean she called 911? Especially if you think the broad killed the man. If you think that she did this and your client didn't, you're going with the third party culpability defense. So you might want to know everything about fucking Jennifer Drake. That's how pissed I am about this case. And now people want to talk about the Idaho 4 case. Well, these same people that did this to this man, they're the ones on the Idaho 4 case. And if I'm a parent of one of the victims, or I'm a parent of Brian Kohlberger, I am not happy to see that this is what the hell is about to happen. And it's happening. Wait, we're going to have a preliminary hearing. No, now we're not. We're going to go grand jury. This is unbelievable. So that's what happened. That's what took place. And we're laughing and we're joking. But guess what? A dude and his wife and his whole family who did nothing their whole lives but give to that community literally can't even live there, getting death threats. That whole community in Bonners Ferry thinks that Daniel Moore killed somebody. No, you guys are having picnics with the real killers. Keep on doing that. Keep on going. Crazy. Ready, B?
Yep, let's go.
Did you get some jelly beans?
I'm eating them. We're not joking, though. What we're laughing at is how ridiculous it is. So it's not us joking. It's just how ridiculous it is. And I've stated over and over again how this has affected the Moors. And it doesn't matter that, they've
this is crazy. People shouldn't have jobs.
Okay, let's go on.
So all they're doing here right now is they're playing these little clips Okay. And so there's no reason to look at these clips because it says like video plays here, video plays there. So then we're back on the record. Everybody, let's go back on the record. They're doing all those videos to play all the little clips of the, Miranda, was there Miranda violation? And so we get to, again, these are just the video clips. There's nothing to really talk about for these because you're not seeing the video. You know what I mean? And they bring up, again, that rule that she wants to argue, that is a trial rule. The guy says, okay, we've reached noon. Let's go ahead and recess. Like they've only been working for 2 hours. Okay, so they take a recess. Then they're back on the record at 1. Again, they're not live streaming. They're about to. They're finishing up these exhibits. And they go right here to... True, we are laughing at the ridiculous. None of us are laughing or joking at this crime or this death. Absolutely. Absolutely. Yeah. Hot ham, absolutely. Idaho is a third world country. I wouldn't live there. As much as I want to go and be there for the trials and stuff like that. All right, Court, then I believe that Detective Van Leuven was still on the stand, and then we called Jennifer Drake out of order, and then we went into playing all that stuff. So I don't know if we're finished with Detective Van Leuven's direct examination, let alone cross. So that's what we're gonna pick up.
Your Honor, I don't have any further direct examination. We have the authentication of the videos. Those videos have been played. We certainly understand that the defense is going to raise the motion to suppress issue from there. But if she has questions for cross-examination for Detective Van Leuven, then he needs to be placed back on the stand.
Oh, I do, Judge. All right, then, Detective Van Leuven, you're still under oath. Please resume your stand. May I begin, Your Honor? Please. So you're going to be Van Leuven?
Yeah, because this is you being the defense. Is how you wanted to do it. You wanted to be the defense.
That's cool.
So,
good afternoon, Detective Van Leuven.
good afternoon.
Do you go by detective or detective sergeant, or what's the best name for you?
Sergeant, probably.
Sergeant. Okay, sergeant. So sergeant. You became a sergeant again in what year?
I think it was December. It was 2015.
Okay. You're not sure?
I'm not sure.
All right. You have some other education or training besides law enforcement?
I attended the University of Idaho, where I graduated with a Bachelor's of Science degree, and then I attended law school for 1.5 years.
What was your Bachelor's of Science in?
I had a dual major in political science and criminal justice.
Okay. And you started law school directly after your bachelor's degree?
I served in the Navy. It's a long story, but I had a very brief stint in the Navy before going to law school.
Did you leave early from the Navy, or what happened?
You want the full story?
Well, I guess if you could say it briefly, but if it takes an explanation, that's what I'm asking.
Sure. I'd planned to go to work for the FBI, but part of me had always been interested in flying. I worked as a summer intern for Larry Craig back in Washington, D.C. when I was in college, and he had a liaison that worked out of that office who was a Navy commander. She and I became friends. One day, I expressed an interest in flying for the Navy, and she told me I was not aware of this, that the Navy was in need of.
Sorry about that.
Pilots, and if I could qualify, then they could probably get me into an officer candidate program to be a pilot. At the same time, I'd been applying for law school, and my law school choice was the University of Idaho, but I had not been admitted. And so the Navy, after testing, indeed gave me a contract to be a pilot. I went to officer candidate school with the understanding that I was going to have to serve 7 years in the Navy. After getting there, after a month or so of OCS, 2 things happened at the same time. One is we had people from our designators come and meet with us to discuss the process after OCS. And I learned that my commitment was going to be more like 13 years, not 7 years, because I had to wait for slots in schools to come open.
So you didn't, you decided you didn't want to make that long of a commitment?
I didn't. But the fortunately, the same week that happened, I got a call. I'd been late, accepted to law school, and if I could be there by the following Monday, I could enroll in law school. So I dropped on request from OSC. I thought up there they said OCS, and went to law school.
So what did you enroll in law school?
I'm sorry.
When did you enroll in law school?
I think that would have been 99.
Again, just guessing about that.
Yeah, to my best of my recollection, it would have been 1999.
Okay. And then did you graduate from law school?
I did not.
Why not?
I really did not like law school, and I was not getting good grades in law school, and it was just not for me. And at the same time, there'd been a career fair at the U of I where ISP was hiring, and I decided to give ISP a whirl, thinking that I would work for ISP for a few years and then go work for the FBI.
So were you failing law school?
Objection, relevance, Your Honor.
Sustain. So let me just ask you this. You attended Post and you got all kinds of training at Post. You talked a little bit about that when the prosecutor was talking to you, right?
Yep.
And of course, one of the areas of training is Miranda, right?
Indeed.
And custodial interrogations, right?
Sure.
And you learned during your training experience there at the Post Academy that when you have a person in custody, that you must advise them of their Miranda rights, right?
No, not necessarily.
You didn't learn that?
I did not.
You learned that when you didn't learn that when you interrogate someone when you're in custody, when they're in custody, that you need to be advised of their Miranda rights, or their statements will be able to be used against them. You didn't learn that?
I learned that, yes, ma'am.
Okay. So, and you learned that you actually have to read them the rights when they're in custodial interrogation, right?
Well, you have to advise them of their rights. Whether you read them or not is sort of up to you. I've always found that reading is a better policy because you don't forget things.
Right. And we see on the video where at about 3 minutes into the interrogation of Dr. Moore, you pull out your card, right?
Mm-hmm.
Your Miranda rights card?
Yes.
You carry that around in your wallet, right?
In my ID, yeah.
So you could be sure to reference that and read it and not miss anything, right?
That's just my practice. That was advised to me in training a long time ago, that the best practice is just to read the Miranda from a card. So that's what I've always done.
So you don't forget what you need to advise them of.
Right.
Okay. And so that's what you did here, right?
I did.
And then you continued to ask him questions.
I did. It's my understanding that in Miranda, if you intend to arrest them.
Okay. I didn't ask you a question. So my next question is this.
Mm-hmm.
There was a point in time where you started to get quite frustrated with Dr. Moore because he wasn't giving you what you were hoping to get, right? Is that fair to say?
I don't know if frustrated is the right word. I was sort of, I expected that he was going to understand the situation and answer us differently.
Right. Well, the situation was exactly what you told him, wasn't it? Was it that?
It was.
If he didn't explain that he was going to be booked on first-degree murder, right?
I didn't. I could not put myself in his mind to understand his intent. I only knew what I knew.
Right. And you told him that if he didn't explain why he did this, he would be booked on first-degree murder, right?
Your Honor, I'm going to object that we have the tape and evidence or the recording and evidence, and that this is the best evidence in this case, as opposed to sitting here cross-examining and.
Well, I mean, I guess.
On something that was already.
I guess if they want to stipulate.
On record, if I could please.
That it was a.
Finish my objection before I'll stipulate to the recording because we have the recording.
Your Honor, I'm going after the issue of custodial interrogation. That's something that we can establish through this witness. Well, although I don't think this question bears on the point, I'm going to sustain the objection because I basically sustained your objection on the same issue. Sure. Which was best evidence, and we've seen all this in the video, so it speaks for itself. Okay. So now we see on the video, and this is where you can maybe get some explanation that when anyone enters the room, there's a beeping noise, right?
Yep.
And that's because there's a code you have to enter to get into the door.
Yep.
Right, because the door is locked.
It's locked from the outside, not the inside.
Okay, so was it your position that at that time that Dr. Moore came in? Well, let me just back up. When Dr. Moore came in, was he asked to remove any articles of clothing?
Not that I recall.
Wasn't he asked to remove his belt before he came in to see you?
I'm not aware of that. He may have been. When he first came in, other detectives met him because I was already involved in another interview with Coroner Millette at the time, so I was not the one that greeted Dr. Moore when he came in.
Okay, so, and he was there and you gave him his rights and you proceeded, as we can see on the video, to ask him about the crime, right?
Yes.
And when you were asking him about the crime, and I'm just kind of laying foundation, Judge. I'm not meaning to recount. Obviously, the video is exactly what happened, but there was a point in time where Dr. Moore makes a statement to you, right, about counsel.
Yeah.
And we saw on the recording what it was. And I just want you to explain to the court how you understood what happened. So we see on the video what exactly happens. You accuse him of first-degree murder, and he says, well, I guess if you're going to do that, then I need to speak to an attorney, right?
Pretty close.
Okay. And so at that point, we can see on the video where you close your book and you sigh heavily, right?
If you say so.
Did you not just watch
Your Honor.
the same video?
I don't recall whether I sighed heavily or not.
Okay.
I recall.
Well, it speaks for itself. We'll let the video speak for itself.
Sure.
But I want to ask you this. You stopped at that point.
Yes.
And why is it that you stopped at that point?
Because I wasn't sure whether he'd invoked Miranda or not. And so I wanted to stop because I didn't want to violate his rights and leave the room and discuss our next move, discuss what should come next.
Okay, so tell me what you did when you left the room.
What I did?
Yeah, you said you left the room to go discuss, and so tell me what you did. Who did you talk to?
Well, I talked to Gary Tolson.
The detective that was in the room with you?
Yeah, we spoke with Assistant Chief Marty Ryan, who was there. I think Dave McClendon was also there, I think.
Who's Dave McClendon?
Dave is a detective with the county. We were using their offices. I believe Caleb Watts was there.
Oh, also another deputy.
A detective with the county.
Okay.
And then I believe at some point they left, but earlier there were other ISP detectives, which were sort of in another sort of a break room down the hall. And so I went back into that room, sat down, and we discussed what he'd said exactly and whether that rose to the level of invoking Miranda.
So you all conferred among law enforcement on that issue?
That's right.
And so you made the decision among law enforcement officials as to whether or not you thought he had invoked his right to counsel.
Yeah.
And then you decided that he had not.
We decided it was ambiguous at best. It wasn't a clear indication of Miranda.
Okay. Well, you certainly understand and agree that what he said is on that videotape, and we can see what he said there.
I do.
So whose decision was it that, you said that it was equivocal and it was ambiguous. So why didn't you go back in and talk to him some more?
We had discussed who should interview Dr. Moore before this ever happened. And
now my question is, why did you? I'm asking you for why you did what you did, not what you discussed, but why you did what you did.
Well, I was trying to explain. Why I did what I did is I thought Marty Ryan may have better rapport with Dr. Moore than I did.
Okay, so Marty Ryan went in? And you were there when Marty Ryan began questioning him, and you watched the remainder of the interrogation, right?
I did not know.
Wait a second. Okay, let's just back up. You are the lead investigator in this case.
Objection, Your Honor. This is an argument. This is argumentative as to why he didn't. He stated he wasn't there.
Well, I'm trying to get at that.
The purpose for why he wasn't there isn't relative to these proceedings.
Overruled. I'll allow it.
Thank you.
You are the lead investigator in a murder investigation, correct?
Indeed.
You've been working this case since March 12th when Dr. Drake was killed, right?
Yep.
You took over as lead investigator. So as lead investigator, you organized what everybody was doing, or at least had some direction to everybody on where to send the reports and what to do next, right?
Yep.
Is that a yes?
Yes.
So when you're saying that, well, you're interrogating a prime suspect in a murder investigation, you left and didn't watch?
Objection. Relevance.
Can I
answer the question?
Overruled.
Can I answer the question?
Please do.
First of all, I didn't. I went in the room where the camera was a couple of times, but then I left that room because I didn't like the door opening. I went down the hall and sat in the other room with some other investigators, and I listened to the audio portion, as good of quality as it was. I listened to most of it, but at the same time that was happening, I was also trying to coordinate with all the different search warrants that were happening. And I was on the phone a lot. So I was answering questions that were being asked of me at the same time, trying to monitor the interview as it was going on. And there were other detectives, Leslie Leuven particularly that I recall, that was listening to it and was sort of updating me as things were happening.
All right. Let's just clarify a few points. When you were in the room and Dr. Moore said, well, again, we're just paraphrasing, but the record speaks for itself. So I guess if you're gonna do that, and you had insinuated you'd charge him with first-degree murder, then I need to go get an attorney. When he did that, just to clarify, he raised both of his hands like stop.
Your Honor, I'm going to object to this line of questioning. The court watched the video. It showed what it showed. The voices said what they said.
That's true,
and that is the best evidence. Now,
but Your Honor, to make a record, I need to describe certain actions that took place in the video that you can't hear, and it's not part of the record. It's in essence, the video shows it, but to make a written record, and there'll be a transcript of this, we need to describe some of the actual physical behaviors of people in that interview. I will allow for that purpose, and for that purpose of inquiring how the detective interpreted the body language. Right. And not quarrel with what the video shows, because it's speaks for itself. Sure. But you saw that, right? You saw Dr. Moore put up his hands like this at you. If you're going to do that, then I need to get an attorney, right?
I think so.
Okay. So what did you do to try to make an attorney available to him after he said that?
I didn't do anything.
You didn't provide him with a phone?
No.
You didn't allow him to come out and have access to a phone or his own cell phone?
He wasn't in custody. So, I mean, as far as me allowing him to do something, he could have gotten up and walked out that door.
So wait. So you're telling me that after accusing him and telling him he's going to be booked on first-degree murder, he wasn't in custody?
He had not been arrested.
Well, that's true. But do you think that anybody being accused of first-degree murder would feel free to just get up and walk out?
Objection. Your Honor, it's not an objective stand, or it's not an objective or subjective standard in this matter. It's up for the court to determine whether or not he's in custody. If there's some type of argument where he makes accusations that is first-degree murder, what he interprets by looking at the evidence, that's one issue. But to go, and he read him his Miranda rights. So if we're talking about that.
Your Honor, that's not the issue. Mr. Hall, maybe we can shortcut this a little. Is the state taking a position that this was not a custodial interrogation?
Mm-hmm.
So the state, okay, is stipulating, perfect, that it was custodial.
Yes.
Oh, sorry, perfect. All right, so we can move on. Witness's understanding of... that would be irrelevant.
For purposes of this preliminary hearing, that's
Yes.
fine.
All right. So with that in your pocket, very good. Okay. Miss Bolden, please proceed. Okay, so during the time period that Marty Ryan was speaking to him, you were kind of distracted and you might have heard some of it cause you were listening in by audio, right?
That's right.
Okay, you mentioned several times in your interrogation of him certain things that you said you could prove. You and I think at one point you said you're sunk. So I want to get to the bottom of what you actually understood you could prove at that point.
Mm-hmm.
You made a reference to surveillance videos.
Yes.
Correct. And in the video, you actually referenced that you had that. Well, actually, you referenced first. I think it was Tolson that referenced that you have. Do you know what how we can track you? It made a reference to his cell phone and his truck, right?
Mm-hmm.
And if you could say or no for the record.
Yes.
Okay. And you made reference to geofencing, right?
I don't know if I did or Gary did.
Someone did, though.
Someone did.
Okay. And so you gave Dr. Moore the impression, or were trying to give him the impression, that you had this evidence placing him in the exact locations at these exact times, didn't you?
Your Honor, I'm going to object to the line of questioning. None of that had been introduced into evidence. If we want to...
But it has. It's on the video. I'm having him explain it.
May I please speak?
Sure.
The objection is for me to speak and then you to respond.
I'm sure the judge will guide us.
Your Honor, if we presented evidence of that information during the course of this hearing, the actual geofencing or the collection of cell phones or the Bluetooth that referenced with regard to the card, that's fair game. Officers can represent to defendants things that they have. They don't have to because it's obviously there to get the defendant to talk. And so we're not here to have a discovery inquest, which would allow the defense counsel to go into all of these things that may have made representations to, or may not be true, because that is not what we have a recording of what was said. That's what the court gets to look at from the standpoint of statements made, but we have not introduced any of those pieces of evidence.
Your Honor, here's how I would respond. So we have a record of a videotape where the police may be, providing false information to a defendant to try and get him to confess. That is a common tactic. What we're doing is making the record clear as to what their actual evidence was. Because right now, as the prosecutor said when we started, if we get his confession in, we're not gonna go into the surveillance videos. We're not gonna try to go anywhere into that. So we need to establish that the evidence is not part of something they can actually prove. It is not probable cause to support the charges in this case. And so I think it's on record and we should explore it. I'm going to allow it. The evidence of the video does open the door, but as far as going into it in detail, I would reserve the right to cut that off. I think the proper line of inquiry is, was that legit or was it a bluff? Sure. And when we get an answer to that, we move on. Sure. Well, let me just say it this way. You referenced tracking him in all these locations, right?
I didn't.
You had let me say it this way. Maybe I can explain it better. You pulled out a paper, right?
Yes.
And the paper you kind of pointed to, and we show you here, and then you said, we show here, you there, among those lines, right?
Yes.
And you did that to try to persuade Dr. Moore that you had evidence to convict him, right?
Yes.
And you actually did not have evidence that placed him specifically at those locations at those times that you said, right?
No, that's not right.
Okay, well then let's go through that then. So,
Your Honor, here is the juncture that the court referenced. The court said that you'll let him go ahead and answer to find out whether or not they have it or they don't. He's saying that they have it. Now we're into a discovery inquest, and that isn't proper.
Miss Bolton, actually, they don't have it, and he knows he doesn't have it. So what the problem is this: there is a whole bunch of speculation in the surveillance videos. What they pieced together, there's portions missing. There's this timestamp that are off by 3 hours. They have not authenticated that video. So he said, oh yeah, it's all right. I get it, to go into authentication, and then let's see how that's right. All right, my ruling on this is going to be, since the state is not presenting this at this point as actual evidence placing the defendant at the scene, that basically, as far as I'm concerned, it's a bluff. I'm going to take your word for it for the purposes thus far. Okay. So going into whether or not they could prove it by geo-tracking and fencing at this point wouldn't be relevant. Okay. So you're taking, just so I'm clear, you're taking it that they can't prove it, and we're just, for the sake of argument, okay, it's not part of the state's presentation of evidence at this time. Very good. All right, let me move on to the next thing. There was a point in time during the questioning by the prosecutor in the introduction, before we got into all of these videotapes playing, where you were asked about the window where Dr. Drake was shot, right?
Yes.
And you said you asked specifically about measurements between the bottom of the window and where the bullet hole was, weren't you?
Yes.
The main bullet hole was measured 2 different ways. It was measured,
the one above that. That's it.
oh, sorry. Thank you. And you said you asked specifically about measurements between the bottom of the window and where the bullet hole was, weren't you?
The main. You can't read when you're scrolling like that.
Right there.
Like, did they have? The bullet hole was measured 2 different ways. It was measured in a crude way by me with a tape measure, with photographs taken, which I'm sure you've seen. It was also measured electronically with a laser instrument by Coeur d'Alene PD officers that came up and used that. So, for purposes of court, we can absolutely show you, or whoever wants to see where the bullet hole was, how high it was, exactly where it was.
So what was the distance from the bottom of the window to where the bullet hole was?
I can't answer that question accurately right now without without referring to reports or photographs or other lab result type things.
Do you have those with you?
Nope.
Okay. So what was the distance from the bottom of the window to the roadway or to the alley where a person would stand if they were going to, for example, shoot through it?
To the best of my recollection, the bottom of the window to the alleyway was approximately waist high.
Whose waist?
My waist and the waist of the other investigator that was out there assisting and taking photographs.
Which is how many inches?
How many inches?
Yeah.
I can't tell you that.
So there was some testimony about, and you sat here and watched a video, and you, right?
Yes.
And you saw the questioning by Marty Ryan about how he shot through the window, Dr. Moore, right?
Yes.
And he said, this is my favorite part of this interview, by the way, guys. And he said, was it here at the waist or was it up here at the shoulder?
Yeah.
You know? And do you remember how he answered?
No.
Oh, so you sit here and you don't even know what you claim someone you've alleged has
All I remember.
committed murder?
Your Honor, I'm going to object.
How they committed that murder?
I'm going to object. It's argumentative.
Sustained. You don't know how he did it?
Objection. Asked and I think that's answered and asked her. It's really asked and oh, shit. Asked and I'm sure that says asked and answered.
Well, that's a different question, how he did it. If the witness can respond.
As I recall, he said, what difference does it make? Or words to that effect.
Okay, well, does it make a difference to your investigation?
No.
So if a person who confesses to a crime gives you information that is contradicted by the actual physical evidence, Does that make no difference to your investigation?
Objection. Hypothetical. Not an evidence. Not a.
Overruled. I'll allow
Thank
it.
you. In my opinion, whether he was shooting with his arm outstretched or whether his elbow was bent wouldn't have made a difference in this situation.
Okay. Well, let's talk about what you also testified about, which was the trajectory. Remember, we got into that and whether you were qualified to talk about trajectory,
Yes.
right? And you said that the trajectory was downward,
That's right.
correct? So did you take measurements of where, obviously we have the autopsy report and evidence, and where their measurements as to where the gunshot wound was in relation to where, the height of Dr. Drake, if he's sitting or if he's standing?
The injuries to Dr. Drake were consistent with him sitting on the stool in front of the window, leaning forward.
And so if you're measuring from the stool to his gunshot wound, how many inches was that?
I can't tell you that right now.
And what was the from where he was sitting and where he was shot? Did you measure to find out what level in the window that the gunshot would have had to come through to hit him at that location?
That information, again, is all recorded in the electronic scans that were done. So that information is available to you, but I can't tell you that off the top of my head today.
Okay, but you seem to be really confident that it was a downward trajectory.
It was.
Okay, so you said that's the person, it doesn't matter if they're standing up or they're down here at their hip. Doesn't that make a difference in terms of what the trajectory of the bullet is?
Certainly.
So do you typically, if you have you're familiar with guns, right? You use firearms all the time?
I am.
And that's part of your extensive training and experience, right?
Sure.
So if someone has a gun at their hip and they're shooting straight, how's that going to have a downward trajectory?
If they're shooting straight, it wouldn't have a downward trajectory.
Okay. So they'd have to maybe be standing up and pointing down?
Not
Right?
necessarily, ma'am.
How would you get a downward trajectory unless you're pointing the gun down?
Well, you could have your arm straight and have it tilted down.
Oh, okay. So your arm straight and tilted down?
Or arm straight with your arm down.
Right.
Or arm straight with your wrist tilted down. Or arm
So
bent with your wrist tilted down.
right.
Your arm could be bent and still pointed down. I don't know. I don't know how exactly he held the gun in the alley that night, ma'am.
Right. So with the evidence, though, from the confession that you got from Dr. Moore, you said it didn't really matter. And you didn't remember what he said about how he shot. But did you take any measurements of Dr. Moore see how high he would be from the window at the time of the shooting?
No.
And whether it would be a difference if he said he held it at his waist or whether he held it straight out or whether he held his hand down?
Again, the trajectory of the bullet through the window and through the shade was consistent with an adult person firing from outside the window standing on the pavement.
An adult person of what size?
Of average size, an average male.
That sounds a little bit like speculation.
Okay.
Did you do any measurements to confirm any of your idea of what an average person would do in shooting a firearm like this?
Your Honor, I'm going to object to relevance at this time and also beyond the scope. The only thing that they talked about was the downward trajectory from the window through the blinds that were there, not the actual shooter and the position that the shooter was. So it's beyond the scope of direct examination.
Ms. Bolton, I don't know that it's beyond the scope. We're trying to understand what, he's testifying that this is what happened. And this evidence that he has puts him at the scene. And he did all this careful investigation. And it looks like he doesn't even know how these things happened. And it's relevant. It's called impeachment. I'm going to allow it, but I'll ask you to try to make it concise so we can move on to the next topic. Certainly. So before we kind of finalize on the trajectory issue, did you compare you said you made a measurements to determine the downward trajectory, right?
We did two different things. One, in a crude way, we inserted a rod, a ballistics rod through the center of the holes in the window, as well as the blind, and then took photographs of showing the downward trajectory angle of the rod, so it's visible in photographs, so that any person can look at that and see that it was a downward angle. And not just a downward angle, but also an angle, I believe, from left to right as it went in the window. And then we measured with a tape measure where those holes were both inside and outside. And again, I say that was crude measurements, but you never know what may be useful later. The more precise measurements were done using the laser scanning system that Codaline did. And that was so later on, if it was important for court purposes, you or anyone else would be able to go look exactly where things were and how high they were and all that.
Did you when you kind of came to these conclusions about the down trajectory, did it make a difference, for example, what Sally Aiken, the pathologist, said about what direction she saw the bullet go based on where it landed in his body?
Well, I didn't obviously know that information until later, so I knew that the bullet had entered the building on a downward trajectory, as you say, when I saw the building. And it wasn't just me. There were other experienced detectives there also that were all seeing the same thing and were conferring and coming to the same conclusions. Once we got the autopsy the report back, we saw where the entrance wound was and where the bullet ended up. Then, as commonly done, we got to see how that lines up with the hole of the bullet coming into the building. In looking at
What did you find?
Well, in looking at those things, the only thing that made sense was that he was sitting on the stool that was directly in front of the window and that he was leaning forward.
Okay, so you have to make a lot of assumptions.
I'm not sure I take your meaning by making assumptions.
Well, according to the way the bullet hole was entering the body, it went from a lower rib to an upper rib, right?
Right. So if I may.
So from a lower rib to an upper rib would be an upward direction, right?
Right. So he's leaning forward like this. That's the trajectory lines up. That's the only way that makes sense.
Okay. And did you collaborate with Dr. Aiken about that?
Nope.
Okay. Let's talk about some other things that happened in your investigation. Actually, the night of the shooting, there were some other eyewitnesses that had made some. Actually, one of them made a 911 call. And another one, the young man and his girlfriend both gave statements to the police, Idaho State Police, and/or local law enforcement about a suspect they saw, correct?
Yeah.
And they gave a description of that suspect, didn't they?
Objection, Your Honor. Beyond the scope and relevance to this proceeding.
It is beyond the scope of direct, although the defense could always recall Detective Van Leuven if they wish to offer it. So, well, that's what we would do. This is a probable cause determination that I'll leave it to this person. The state, do you want to stand on the objection and we'll just have the defense recall after the state rests?
No, we'll just, actually, I would, because then she's got to ask direct questions as opposed to leading questions.
No, we would of course suggest that this is a hostile witness and can continue our cross-examination.
He's not a party to the proceeding.
For the moment, the solution is I'm sustaining the objection as beyond the scope. Okay, then. We have no further questions on the scope of the initial questioning, and we will recall him. All right, thank you. Mr. Hall, do you have any redirect?
No, Your Honor.
And that's where we're going to stop. This is insanity, but you guys got a full taste of it right there. Bella, what do you think?
I think that this always falls to, everyone wants the truth to come out. And when someone's facing a murder charge, it's up to the defense attorney to make sure that your eyes are on. And so a lot of times in prelims, you don't have all the evidence in yet. But what you do have you have a duty to not take anyone's word for it. Like, you need to see it. And this is an example of that. Like, you have to see the evidence, play the evidence. If you're going to stipulate to something, make sure you stipulate to it in chambers and have seen it before you stipulate to it.
What do you think about, right here, it's, you guys, this is people that are medical. This is really important right here where they're talking about the trajectory and that, the rib.
If they don't have rods going and showing, Scott Roeder would do this, right? So there's people that do crime scene reconstruction. So the rods don't just go into the window in the bullet holes. You would have to show where the body was, where you think the body was when it was shot, right? So I understand that he's saying downward trajectory because they're probably saying he was leaning forward. We haven't seen the autopsy photos.
Yeah, but that's where she totally messes him up, and she says, well, did you see what Sally Aiken said? And then he says, well, I didn't know that till later, but yes. And her report says it's right here. And it says, so from a lower rib to an upper rib would be an upward direction, right? Right. So he's leaning forward like this. But what you're not understanding is if you're leaning forward like this, okay?
Yeah,
if you're leaning forward like this,
mm-hmm.
That still doesn't make any sense. If you're a lower rib to an upper rib, it doesn't matter if you're leaning forward. That's impossible.
You would have to be like leaning down all the way, like tying your shoe.
Okay. So basically, I cannot believe that. Who's this judge?
Well, I think his last name is Jillian, but it says it up there.
It's impossible. It's impossible what they're trying to say. And then they're over here like, so you're saying that when someone tells you how they did a crime and it doesn't match, like that's a problem. And he's over here like, doesn't matter. It doesn't matter.
Well, do you want to explain that a little bit? Because I don't think anyone really knows what happened there with the whole Miranda thing and how long they kept off for more.
It just means this. If somebody tells you how they committed a crime, if I say that I killed somebody with a gun,
a false confession is what you're talking about.
No.
Oh, no? Okay.
Well, it's a false confession, but if something is just totally, if I got you to confess to something and the stuff that you're telling me does not match the evidence, she's saying, isn't that a problem?
Mm-hmm.
And it's like, no, to them, it's not a problem. That's why she was asking, well, doesn't it matter that the confession that would be given matches the evidence? And that how do you not, I don't even know who to blame here because he's saying that he doesn't have these measurements. Well, I would expect the defense to have the measurements. Well, here we measured the window.
What happens is the defense has already, that's all the stuff, they should already know that kind of stuff. And that's why the prosecution's saying, the state's saying, this isn't discovery. Like, this isn't what we're doing.
Fuck discovery. You don't need discovery.
Right, but he's not like going into like measurements.
No, but you're allowed to, you can, at this point, what could happen here is you can say, have you seen, is this the window? Okay. Does this look familiar to you? All these, like he says, like the labs, this was sent here. You're saying that we don't have this? I mean, do these numbers ring a bell to you? Like, how do you not have, you don't have a draft of your notes? You don't, so your report that you wrote up, you don't have that here today.
She said, don't read from your notes.
No, but he said, no. Then that's something totally different. It was about,
No, but like, this is just
procedure. He asked him, I'll show you.
I know, but this is procedure. I remember the time, but this is procedure. She needs to know as a defense attorney. If she doesn't have her eyes on it.
Did you bring those here with you today, your reports? She asked him and he said no. And she says, okay, well, can you, you have no estimation. Well, I'm saying as a defense attorney, you would call your own expert. You would call your own expert. As a defense attorney, you would call witnesses. Why didn't you call Isaac Funderburg to stay on the stand and his girlfriend when they say, I heard 2 gunshots. Where's the other bullet? Where's the casing? When you were there, did you pick up any casings? So Mr. Moore picked up the casings too? Where are the casings? Did you find the casings? And then how about this? When you were reviewing the CAD notes and the MEs, or not the MEs, but the medic people come through and they say to you, we didn't find a bullet. Like, were you present at the autopsy? When did you do these, fucking laser, we started doing all this crap.
Crude measurements.
Yeah, when did you do that? So you could find that he was shot? Because the medic people, they couldn't find an entry point. When did you find the entry point? Like, what the fuck is going on? And I'll tell you what's going on. People aren't doing their jobs. That's what's going on.
Well, I mean, that's in a nutshell. But yeah, I mean, it like, to simplify it, that's what it is. I mean, this is important. This isn't like, this is someone's life.
This is murder.
And also, you want justice for the victim. I mean, paramount to everything. And you don't want redos. Because redos cost money. Redos are a waste of resources.
I think Mr. Moore should own the whole damn state.
I don't know if he wants to own the state. Do you want Idaho, Mr. Moore, Dr. Moore? I do not. I have checked. I don't want Idaho. Can I have Pennsylvania?
This is just wild. But to hear, I mean, we're going to stop here and you guys are here, like the rest of it comes about tomorrow. But when I was reading this and I'm just like, wait, they just said, okay, we're not going to put in any of the surveillance. It's out. Okay. And so what are you using? What are you using for your, and the only thing that they were presenting, their case was, and this is where I would have rested. I wouldn't have gone any further because they're saying that they're just going off of this false confession. Like after I would have had this him-ho up there and then, do my, my cross-examination of him based on as I have to call him as my witness because they were talking about like, oh, that's leading and bullshit. Or outside the scope. And then they're like, well, I'll just call him as my witness and it won't be outside the scope on my direct. And then I'll treat him as a hostile witness so I can do leading questions. And the point of all of that is that at that point, I think she's stressing right here that how did this go past and say, yep, I do believe that probable cause exists that you committed this murder.
Yeah, I don't know.
And
especially in the end, how exhibit number 2 is protected.
Yeah, we that. Like, but the other thing is how Brian Kohlberger was set to have like a week-long preliminary hearing. How did this preliminary hearing just literally, it was like 4 hours, 5 hours. It was 10 to 5 maybe, and there was an hour for lunch. All these technical issues. No witnesses. How does the defense call no witnesses?
I don't know. But if you're not going to call witnesses, then just rest without. I mean, you're not authenticating this 911 as it is, so like just rest.
So on that note, guys, we love you so much. Come back and check this rest of this out because you want to hear the end of this. The way that what they do to totally pull out from the record exhibit number 2 is unfucking believable.
Yeah, it really is. You guys do need to check that out if you've been invested in this case. And You can't get this stuff anywhere else, so it's only here. Lana's channel. Lana, thank you so much for having me. Thank you, Moss. Thank you,
Oh,
everyone.
thank you for just being the best voice on the streets.
You know, this is just what I do for a living, apparently. All right. Thank you guys so much.
Thank you. Love you, girl. Blah.
Talk to you
Give it up for
soon.
Bella. Go check her
Bye.
channel out. Bedtime stories. Tag your channel up there. Write it in chat, love. All right. Well, on that note, join me back for part 2. It's gonna get wild. I might be doing a Midnight Express. Let's go over and see if our boy got arrested yet. What's his name? Let's go see if he is still armed and dangerous. Thank you there, Miss Kelly. Thank you there, Boston. All of you guys. Yeah. It ain't easy getting your hands on this type of material. You guys, lower rib to upper rib. It's like somebody coming up to you and like shooting you such in close range and shooting like up and in. And you know whoever was here last night talking about how you would do it. And if you knew that he was a drinker, you would shoot for his, that area to get up in his, and I guess like the fatty. He's not a fat guy, but this is a close range shot and it was up and into his ribs. So I'm just curious about people that are medical. Email me. Up close pillow. And that would make it so no blood. I personally believe that the gunshot wound is superficial. I believe that he was shot after he was dead. That's my take right now. Based on the evidence that I've uncovered with what was going on with these phones. I'm going to look a little bit more into Eldora Getchell and her, yeah. Thank you. Until next time, guys, rock it, roll it.
Like brains, and like if you need a lot of brains, you're gonna be in trouble.